Good morning. I'm Jack Calvertinas, and I'm looking forward to this discussion here in beautiful Big Sky, Montana, so we can better understand some of the most important trends in employment law, and specifically areas where employees and their employers are having their freedom to associate, freedom of speech impacted, and thoughts of how companies can actually best navigate this very complicated landscape. We're here in 2024 on the heels of some very significant court cases in the throes of a major presidential election and control of the White House and Congress up in the air. And much of what we're going to be discussing will be impacted since elections do matter. But for now, let's work through some questions with some of America's top labor and employment experts. Glenn Spencer, you represent the U.S. Chamber of Commerce, Senior Vice President of the Employment Law Division, spent years in the Bush administration, actually, at the Department of Labor. I know you go around the country speaking to your members. The Chamber is involved in so many different legal cases and regulatory matters. Really want to talk to you about sectoral bargaining and talk to us a little bit about what that is and what the threat is to employers and to employees nationwide. And after that, I want to turn to Michael Latito and talk about what he's seeing in California.
So sectoral bargaining is a concept it exists in Europe primarily, and it means that the Central Trade Association for a particular industry will negotiate with a particular union, and then everybody in that industry is covered by that master contract. Now here in this country, labor advocates tend to say, if workers want a union, they should get a union. I think everybody on this panel generally would agree with that sentiment. We'd probably change the wording a little bit. If a majority of workers want a union, they should be able to vote for a union. Under a sectoral bargaining arrangement, essentially the government says, we don't care what you think. We're going to put you in a union and we're going to set your terms and conditions of employment. You don't really need to negotiate. So that's a bit of a difference between the way some folks in the union movement would want to do it here compared to how it's done in Europe. Here, I think we would refer to this as cartel bargaining, not sectoral bargaining.
Because sectoral bargaining does seem like a bit of a euphemism for what it is you just described.
I think that's the way it would play out here.
Let's turn to Michael Latito. Michael heads up the government affairs practice at the world's largest employment law firm, Littler, and wanted to talk to you about what you're seeing in California, what the Newsom administration's been doing, and I think some recent meetings that you attended.
Glenn's comment with respect to sectoral bargaining is not just some theoretical concept. It's actually playing out in California with the Fast Food Council. The most effective union organizer in the country today is a politician who needs union support. And they passed legislation, such as 1228 in California, that establishes the Fast Food Council. The Fast Food Council is composed of representatives from the SEIU, representatives from fast food industry, as well as a neutral who's appointed by the governor. The Fast Food Council has now had 2 meetings, including one that was very recent. And the union people are being very aggressive with respect to their demands and what they want the council to do. They're asking for mandatory training of 6 hours a year for the 560,000 fast food workers in California that naturally the union or somebody that they'd be comfortable with would actually conduct. I suspect that the newly created fast food union of the SEIU will help conduct that kind of training. They've asked for named contact information of all of the workers for these companies so the union can get in touch with them in order to make sure that they're being properly treated. This is the real threat from an organizing standpoint, and it's happening because with unionization down at 6% in the private sector, you can't organize restaurant by restaurant. You need to go after an entire sector. And this concept will be duplicated elsewhere. The next one we'll come out with it is sometime probably around Labor Day with Minneapolis that will expand sectoral to any business that potentially does operations in the city.
And Jack, I would point out that Mike mentioned the 500,000 plus workers who are in the fast food industry in California. None of them voted to be in a union. None of them voted to be subject to the edicts of the Fast Food Council, but there they are. They have no choice.
This is why we've referred to this concept as cartel bargaining, because while people talk about freedom of choice for employees, sectoral bargaining is exactly contrary to freedom of choice. I suspect that the vast majority of the 560,000 individuals with about 100% turnover have no idea that this is even happening to them.
Here we are in 2024, and the term democracy is used so much that doesn't seem very democratic to me, what both of you have just described.
Well, when you think about how unions organize, they organize primarily through card check and neutrality agreements. So the first thing the union wants is to make sure that the company doesn't say anything. The second thing that they want is to make sure that nobody votes. The third thing that they want to do is just get recognition through a card without any parameters as to how that card is necessarily being solicited. So this concept of democracy, this concept of voting is really quite shallow when you begin to examine how unions are organizing today.
Thank you. Great discussion. And we're going to shift over to European-style work councils. I want to learn really about what they are and understand why they're really antithetical to our own First Amendment rights.
So Works Council, as you noted, again, is another European concept. Most Americans wouldn't know what you're talking about if you told them about a Works Council. But what it means in Europe is you have the sectoral bargaining that's negotiated at the highest level and across the industry. Then Works Councils are at the individual location, and they will essentially translate the terms of that contract into what it means for that particular factory or location where the employees are. So it's a localized version of a sectoral bargaining arrangement, if you will. These don't exist in the United States. A couple of years ago, the UAW tried to pretend that you could create one here. The problem being that they are essentially illegal under the National Labor Relations Act. If an employer decided to form a works council and negotiate with that works council over terms and conditions of employment, that is most likely going to be an 882 violation of the National Labor Relations Act. So they've never been done here because they're not legal. So again, it's another foreign concept that some folks in the union movement have tried to bring over to the United States, in a sense, pretending that there's a third way, that you could do a union light, where you would maybe vote for this works council, but it wouldn't be a full-fledged union. That's just not how this would work. We don't have them. You're either in a union or you're not. There's no middle ground there.
So Corey, with your experience in private practice representing very large companies, some of which have domestic subsidiaries, talk to us about how you've been helping to navigate this very challenging area where you have something that's being done in Europe that's actually illegal in this country.
So one of the things that's an ongoing challenge is that the European Union is adopting labor policies that are inconsistent with American labor law and endeavoring to export those policies by way of European enforcement. You know, again, European labor laws are incompatible with American labor laws. It's a much more cooperative enterprise on the European continent than it is here. We have a more adversarial process, and you know, by using these European laws to try to enforce this incompatible relationship here in the United States, it's really creating a challenge for European companies that are trying to do business and grow jobs here in the United States.
Russ, let's just switch to you. We're going to stick on the international front. Russ Brown, longtime experienced labor consultant, and we're going to talk about the UN for a moment and let you educate us on something called the ILO and a decision that they made. You know, the UN is not necessarily a bastion of supporting principles embodied in our free market and democratic republic, and yet in this one case, it has stood up for the freedom of association. So if you want to talk to us about the International Labor Organization and a particular case that I think that Americans will want to know about because it will help them better understand the support that they actually have in this country for freedom of association.
Well, and I think the biggest thing here is that the unions want to portray the grass is greener on the other side of the fence, i.e. in Europe. And quite frankly, it's gaslighting. What they're doing is they're trying to say that the United States violates international labor law when it comes to campaigns and where there's going to be a union election by getting involved in those elections, where in fact the United States meets and exceeds pretty much all the freedom of association. And case in point, recently in Germany, a shareholder got up in a shareholders meeting and stated that a manufacturer, a German-owned manufacturer at one of their U.S. facilities, was violating labor law by not allowing employees to bring in the union of their choice, and that the company had in fact hired firms to help with that violation. When in reality, by firing the firms, which is what they did do, they violated the law themselves. And the case I'd like to bring up is the International Labor Organization's Committee of Freedom of Association, case number 2683. And it involved a union election with a major airline here in the United States under the jurisdiction of the Railway Labor Act. And at that time, and this is in 2010, if an employee wanted to vote to not have a union, there was no option on the ballot itself to vote no. So what they had to do was just simply not vote at all. And the airline ran a campaign. They called it the Get It, Rip It campaign. So basically when the ballot came in the mail, they ripped the ballot up, and that would essentially be vote no. So the AFL-CIO decided that what they wanted to do was codify the criminalization of the United States companies getting involved in these labor campaigns by campaigning on how to vote no in a campaign and other statements that they could make. And they brought a case before the Committee for Freedom of Association. It was case number 2683, and it backfired on them, to be blunt. What happened was the ILO came back with a ruling that not only said the campaign, the Get It, Rip It campaign was legal, but it also went on to state that the employer does have a right to talk to their employees. And in fact, by not doing so, an employee would not have the full picture to be able to make the informed decision when it came to voting itself. And I kind of want to bring that right back home to here in the United States, because what's happening here in the United States with the current National Labor Relations Board and our General Counsel, they are putting a all-out war on companies being able to talk to employees. You've heard a lot recently about captive audience meetings. They've even gone as far as states passing laws, 9 states in particular passing laws that ban captive audience meetings during union campaigns. Well, in essence, this is against U.S. law in itself. So maybe the German shareholder was right that they were violating labor law by not allowing companies to get involved in the campaign.
And this term captive, for those in the audience and who are watching, captive audience campaign, that sounds like just an employer wanting to speak to their employees, and yet it seems like it's a negative, pernicious term that's being thrown around.
You know, it'd be like any other meeting. There is going to be a major business decision at a ballot box, and it's a major business decision that is not made by the leadership of the company. That decision solely belongs to the employees. And it's a meeting just like if you were going to be choosing which health care plan you would be having, to be able to be informed to make that kind of a decision.
So let's wrap up on this note and sort of do a lightning round among our fellow panelists on this particular topic of the rights of employers to speak to their own employees. Corey, and then Glenn, Michael.
Our country was founded on the principles of the First Amendment, free speech and free association. And at a fundamental level, the current administration's all-of-government approach to increasing unionization in the United States has taken a stick to the employer's right to exercise free speech and free association. And it's not just at the federal level, it's at the state level and it's at the local level. State, local ordinances restricting employers' ability to meet with employees and to discuss critical issues, including, but not limited to, issues relevant to labor organizing campaigns. Issues as broad as political positions that the company favors or disfavors, regulatory changes that are important in their position on those issues. These are basic content-based restrictions. Government-opposed stifling of discussion and the free exercise of association. And it's directly contrary not just to, again, these First Amendment principles that we built our nation upon, but it's against decades and decades of well-established Supreme Court precedent, both preserving an employer's right under Section 8C of the National Labor Relations Act to discuss its position in a union organizing campaign, but also the primacy of the National Labor Relations Act in regulating that type of dialogue in the workplace. And as Glenn well knows, this issue is pretty well established in the courts.
It is, and not only do you have a constitutional problem because this is blatant viewpoint discrimination,
Right.
You're allowed to talk about certain things in a mandatory meeting, but not other things.
Right.
But it is also preempted. As you noted, Section 8C of the National Labor Relations Act protects an employer's right to have free speech during the course of a union campaign or really any other time, and that can't be violated. Now, we've seen states like Connecticut and Illinois and other places pass these state-level laws. We're currently suing the state of Connecticut to block their law, and we sort of know how that case is going to turn out because we've litigated this before. Back in 2008, we sued the state of California over a very similar content discrimination law where they were trying to prevent employers from being able to hold these meetings. And that case made it all the way up to the Supreme Court. We won with a pretty big majority, and it addressed this very issue under the National Labor Relations Act, and the court ruled that, yeah, they are. So eventually, these laws will get struck down when we get all the proceedings finished up. Interestingly, the Attorney General in the state of Connecticut told the legislature when this law first was being introduced, you know, this is probably going to be preempted and it might well violate the Constitution, but the legislature did it anyway. So it's going to take a little bit of time to unwind some of these things, but I'm pretty confident that's what's going to happen.
What's particularly disconcerting about this is, for I'm sure some of your members and certainly some of my clients, the ability to combat state or local enforcement of these statutes is pretty limited. Mm-hmm. It's expensive to hire lawyers and fight the penalties that state and local governments want to impose under these types of restrictions. And what happens as a result? Free speech is stifled, and free expression and viewpoints aren't shared in the marketplace of free ideas. And again, that's just totally contrary to what we believe is the founding principles of our country.
And I think that's the essence of the National Labor Relations Act, is that employees should be able to make an informed decision as to whether they want to join a union or they don't. Again, as Russ noted, it's not up to employers, it's not up to anybody but the employees, but the key is they need to be hearing from both sides so they know the pros and cons before they make that choice, because once they make it, there's usually no going back, right? When the union comes in, it's pretty hard to get them out at some point in the future. So it's really important that they understand fully what choice they're making.
Let's turn to Michael. Any thoughts that you have on this discussion?
There's an incredible irony here. We're in the election season. We will be bombarded with speech. Politicians will spend well in excess of billions of dollars educating the electorate as to who they should be voting for: President, Senate, House of Representatives, state people, and the like. And that's one of the hallmarks of America, so that voters can make an informed choice with respect to who they want to represent them. Those same politicians are passing laws that say, you know, with a union trying to represent you, we don't want your employer talking about it. We want to make sure that the voter never sees the union's constitution. We want to make sure that the voter never sees the union bylaws or their financial reports or strike record. We want to make sure that people don't even vote. They sign a card instead, kind of like a petition that you would sign to get a politician on the ballot. But when it comes to me, the politician, sanctity of elections. And you know what? I believe in that. I believe in sanctity of elections. But just like I believe in sanctity of elections as who I'm going to vote for president or my senator, I want sanctity of elections based upon full information as to whether or not I will or will not be represented by a union. That is the essence of the hypocrisy, which takes me back to what I said earlier. The most effective union organizer today is a politician who wants union support.
Thank you. Bringing the passion here on this morning in Big Sky on such important topics. Want to finish with you, Russ.
Let me just say that, you know, Michael very much just hit on it. You know, he talked about the employees will never see the union constitutions, which are typically near 100 or more pages long. They don't see their financial statements of how they frivolously spend monies on things that you may not believe in. Yet with the workforce that we have today, with the millennials and the plurals that are out there, and as Glenn stated earlier, the union percentage is down to 6 point nothing. they're desperate for membership, and they've actually run a very effective PR campaign to reinvent themselves as human rights groups, which appeal to the millennials and the plurals that are making up the workforce today. This creeping in of the European language, we want to put a spotlight on that and expose it for what it really is. That's why we're all here today talking to you for this Labor Day, is that American labor law is fair labor law that gives the right to where it belongs, not to the employer, not to the union, but to the employee of whether or not they want to engage in collective bargaining with a third-party representative.
Well said. I think that is a wrap, because this is a smart, timely discussion, ending a note like that about really what defines our own American system in standing up for these rights of association and free speech. Thank you all.